Let's, as we promised, let's pick up where we left off, dealing with sort of a historical statement in reference to the death penalty in the state of Tennessee.
Focusing on Tennessee, before 1978, the death penalty in Tennessee was available for a large number of felony offenses, and it was simply up to the district attorney, the trial judge, and the jury to decide whether the punishment would be death penalty or life imprisonment or a term of years, whether you were talking about murder or rape or armed robbery or any number of other offenses. Then the Supreme Court stepped in 1972 in a case called Furman versus Georgia and ruled and pointed out that for a long time in our history, the death penalty had been used in very discriminatory fashion. The people who were winding up on death row were folks who could not afford a lawyer, who were almost always a minority, African American, Latina, Hispanic, poor white, and there was very little supervision by the courts of who received the death penalty and who didn't. And the best way to illustrate that in Tennessee is typically in the last 3 or 4 decades, we'll have about 1,000 or 1,100 people convicted of murder in our state prison system. Of those approximately 1,100 murderers, only about 100 received the death penalty sentence. And therefore, the idea in theory was we'll sentence to death only the worst of the murderers, the worst of the worst. But the problem was, you know, if I get arrested and I can't afford a lawyer before the 1972 embargo on the death penalty, in theory I'd get an appointed lawyer, but in practice, all up through the 1960s, if I didn't have my own lawyer, I was in desperate trouble. I wasn't going to understand what was going on as a defendant in terms of court procedure, penalties, and the judge wasn't going to be in any position to help me. And therefore, we filled up death rows all over the country, including Tennessee, with people who were not the worst of the worst. I'm not saying they were angels, I'm saying they weren't the worst of the worst. The Supreme Court got very concerned we were putting innocent people on death row, which we were in at least about 6 to 8% of the cases. That doesn't sound like a lot till you stop and realize that any time on death row in modern times, we've got 3,000 to 4,000 people. So we're talking about a very large number of innocent people at that point. So the court finally in 1976 said if states, including Tennessee, will follow certain procedures, they can reinstitute the death penalty. Our legislature passed a new death penalty in 1978. It was then declared unconstitutional by the state Supreme Court. Finally, about 1979, we got a death penalty created by the legislature that the courts, that the DAs, that the system could use. And that system essentially says juries will determine whether a convicted murderer faces the death penalty or life in prison without parole, that's a newer fashion of it, or a term of years. And the jury can only determine that if the jury gets proper guidance from the lawyers and the judge, proper guidance being, are there aggravating circumstances? Aggravating circumstances in a murder case would be, if I'm the perpetrator, did I kill a police officer? Did I kill a correctional officer? Did I kill a public official? Did I kill a very elderly person or a very young person? In other words, the worst of the worst kind of murders. Juries have to weigh aggravating factors versus mitigating factors. What would be a mitigating factor if I'm that perpetrator? Well, maybe I suffer from mental disease. Perhaps I'm mentally retarded. Perhaps I'm a juvenile who's following the lead of an older person who's the primary instigator, perpetrator of the terrible crimes we're talking about. If I have mitigating factors, juries are supposed to weigh the mitigating factors against the aggravating factors. The idea here is it's not just up to the jury by whatever whim or personal background they have to impose a death penalty. They've got to weigh the death penalty versus life in prison without parole based on aggravating factors, based on mitigating factors. And there are 15 or 20 aggravating factors in Tennessee. I've only mentioned a few of them. Another one, for example, would be I've committed crimes of personal violence that I've been convicted of before this murder.
In other words, Dr. Woods, there's a list you're telling us where the jury can look at 12 or 15 items and sort of check off which should apply? Is that what we're saying?
That's exactly right. And therefore, we have what we call bifurcated trials in a death penalty case. We have one hearing, one trial to determine guilt or innocence. If I'm innocent, case is over, I go home. If I'm guilty, then usually the next day, we'll start the second trial with the same jury to hear whether there are aggravating or mitigating factors. And therefore, a jury has to decide two decisions in a death penalty case in Tennessee. Number one, am I guilty of first-degree murder? We don't have the death penalty for other offenses. All the other offenses in the state are going to be life in prison or a term of years. It's only first-degree murder. Second decision every jury has to make in a death penalty case is, are there aggravating factors and do they outweigh mitigating factors? If the answer is that yes, then the jury may impose the death penalty. In other words, the court's saying, jury, we want you to identify the worst murderers that will receive the death penalty, and you can identify them by following this checklist. We also have some limiting rules. The Supreme Court has ruled over the last 25 years, you cannot sentence a defendant who's mentally impaired, who can't understand the nature and quality of what he did, to the death penalty. You can sentence him to a home, a hospital for the criminally insane, but not to the death penalty. Or you can sentence him for other mental treatment if that's appropriate kind of thing. So there are limits, and then there's this checklist, as you very accurately called it, that guides the jury in their deliberations. But the key to all that is that both sides have a competent lawyer. Because, if you and I are the opposing lawyers, we know going into the case, what we're going to argue is the issue of guilt or innocence. Then if it's guilty, what we're going to argue are mitigating factors versus aggravating factors. We're going to call witnesses for each of those issues, put that proof on to the jury. If we don't have competent lawyers on both sides, then you get what has happened far too many times in Tennessee. I've litigated these cases, unfortunately, no. You get a defense lawyer who has no experience, no qualifications, no knowledge about death penalty litigation, and they drop the ball. Be like, anything else where I'm using an expert, if he or she doesn't have expertise, they're not going to do the job the law requires.
Very good. Of course, let us take this break. I think this is an appropriate time. And we'll be back with our audience following this very, very short commercial break.